Good morning, Your Honors. I represent Gregory Hunt. I want to go straight to the primary issue in this appeal, which I feel is the most demonstrative of the problem in this case, and that is that the appellant was denied right to counsel when he was being questioned by law enforcement. That denial resulted in the suppression of the statements and certain evidence that was obtained as a result of those statements to police. However, the court did permit the so-called confession to his mother that was videotaped and audio taped, and that was actually made a feature of the case at trial by the prosecution. The state mentioned it at least 3 times during the course of the trial and played the video and audio repeatedly during the trial. So there's no question that this was not just some collateral evidence. This was the primary evidence used by the state to convict Mr. Hunt. And pursuant to the case law, anytime that an individual who is being questioned by law enforcement requests an attorney, obviously they are to be provided access to that attorney. In this case, that was not done. And I think that the court failed in its analysis, the trial court, in that by permitting the confession to the mother to be utilized at trial as a feature of the state's case, that was an error, and that is a fundamental error.
You would agree that the mother was not a state actor.
Absolutely, she was not a state actor. But the bright line test that we have from case law clearly indicates that in this situation, that should not have been admissible, because we all know, as a practical matter, that once a person has requested counsel, if they meet with counsel, counsel was going to advise him not to make any statements to law enforcement, to say nothing, to invoke. And had he been allowed to do that, then the confession to the mother would never have occurred. By denying him access to his lawyer, he was not permitted to have that advice. So there's a causal connection, a link, if you will, between the law enforcement denying his right to an attorney and ultimately the confession being made to his mother.
Did the confession to law enforcement happen before the attorney arrived? Isn't that right?
Well, I think that there was maybe a 3 to 5 minute window where the attorney arrived. He was told to wait outside. He made another call. So, I mean, clearly the trial court felt that he was denied access to counsel because he granted the motion to suppress based on a Miranda violation and based on the case law.
But of course, at the point that the conversation with the mother takes place, law enforcement is under the impression that they have a valid confession already in hand. So there's really no incentive to play games as far as letting him have access to his mom. His mother actually was the one who was insistent upon speaking with her son. Isn't that true?
That is correct, but we don't know what the motives or intentions, and we never will know what the motives and intentions of the law enforcement officers were in this case. And I don't think, honestly, it matters, because again, had he been allowed access to his attorney, that statement would never have been made to his mother. And by denying him access to his lawyer, that is a consequence of that denial. And but for that, it's just simple logic. But for that being him being denied access, we wouldn't have this issue before the court today. And I think that's what respectfully, what the appellate court needs to look at is that by denying him access to counsel, this is a consequence that would have been avoided. And I think that the interpretation of the cases support our argument in that once they're denied counsel, then anything that flows from that should be suppressed. And clearly, I can't see how the government can make an argument that if he had been granted access to counsel, that he would then been willing to make that statement to his mother. Because we all know, as a practical matter, the advice would be, don't open your mouth.
Let's set that aside for just a minute. After the fact, isn't it the case that the defendant, Mr. Hunt, actually confessed his involvement in this murder to at least 3 other individuals, one of which was transporting him in his car and saw him with the gun and the blood on him?
I believe there were 2 individuals, and the third had some information. But yes, he did. But as a trial lawyer, those so-called admissions against interest could have been attacked by defense counsel. And we know that one of the individuals received a substantial benefit for testifying against Mr. Hunt. So there would have been cross-examination at trial, and there was cross-examination at trial, that would have helped undermine those individuals' testimonies. There's nothing to undermine a statement to the mother. And that's why that evidence is the most crucial. And that's why that evidence was the feature of the case in the prosecution of Mr. Hunt, because that is the most damaging evidence against him. There was no forensic evidence. There were no fingerprints, no DNA. There was absolutely nothing to tie him to the crime. There was no ID by the witnesses. The people who were actually present at the time were unable to identify him. So trial counsel would have had an opportunity to make the argument that these other individuals could have been the actual assailant. And we really don't know, other than from his statement to the mother. So that's why it's so crucially important that this evidence should have been suppressed. The other issues, and well, one other point on that. Not only was it a situation where the state utilized that as a feature, the analysis under Rogers versus State is that the issue really is, contrary to the state's answer brief, that the issue is did this confession contribute to the guilty verdict? That's the real question. And I don't see how anyone could argue in good faith that this confession did not contribute to the verdict. And that's what the case law says under Rogers and others. So we have a situation where, again, but for this confession, the state's case would have been significantly hampered, and there would have been a likely possibility of an acquittal, given the lack of any other evidence and the ability to attack these so-called witnesses who were part and parcel of the robbery or somehow involved themselves. The other issues that we presented regard the Daubert analysis with respect to Dr. Gamache being able to testify as to his opinion that Mr. Hunt had a higher IQ than the other experts had testified, and actually had an understanding of his ability to either invoke and so forth, as indicated in the trial transcript. We feel that that is inappropriate as well, given that Dr.
Was there any Daubert challenge to Dr. Gamache?
No, trial counsel did not specifically make an objection on Daubert. And that obviously is a problem. The question becomes, did that create a fundamental error by allowing that testimony in? There's no question that Mr. Hunt was compromised to some extent in his intellectual ability. We have Dr. Gamache saying that his IQ ranged from the 70s, maybe up to 85. We have Dr. McLean, who testified that his IQ was 58. But under any analysis, this is a person who was certainly not sophisticated. Yes, he may be able to have function, to be able to take care of himself with personal hygiene and things of that nature, play video games. But I don't think anyone can say that he was a smart individual or that he had a clear understanding of what was happening to him.
But absent some sort of a Daubert challenge, what the trial court is left with is just a battle of the experts. Isn't that the case?
Yes, again, but the question is, by admitting that, does that create a fundamental error when you have that being presented to the court and to the jury, that this individual he was capable of consenting to interviews and such. So I mean, obviously,
Dr. Gamache noted that he was able to drive, he held a job, he had a debit card, he managed money, he played video games, he took his girlfriend on dates. I think Dr. Gamache's testimony was he was functioning about at the level of an 18-year-old.
that was Dr. Gamache's opinion, and the opinion by the defense experts obviously contradicted that.
It does, but doesn't that testimony by Dr. Gamache lend support to the judge's ultimate ruling in the case?
Yes, there's no question that lends support to it. The question, though, is it scientifically reliable? Is it really based upon any reasonable degree of psychological or medical certainty? And I think in this case, that's kind of overstepping when the doctor testifies that because they're able to function in society. I mean, there's people who have Down syndrome that can still function in society, who have jobs, who work, but are clearly compromised intellectually. So I think that was improper to have permitted that to be submitted to the jury. And that also, all of this globally comes into the issue of whether or not the trial court should have granted the motion for judgment of acquittal based upon the totality of the evidence or lack of evidence. And we take the position that because this case was based solely upon testimony, no identification by any of the primary witnesses, and no forensic evidence to tie him to the crime scene. In fact, there was contradictory evidence that would suggest that he wasn't at the crime scene, because there was an unknown DNA profile uncovered under the fingernails of the decedent. So given that was even more grounds for defense counsel to argue that this could have been another individual, that this could have been the co-defendants or uncharged co-defendants in the case. And that's why the primary issue is so paramount. By allowing that testimony of the mother to come before the jury, it was extremely damaging and clearly contributed to the verdict. I would go as far as to say it was probably the basis of the verdict based on the totality of the evidence in the case. And again, given the case law, it's our position that once he requested counsel, or once the counsel requested to see him and he was not informed that his counsel was present at the police station, that should subject the suppression not only to the statements made directly to law enforcement, but to any evidence that was obtained. Because as I said at the beginning, we all know that the advice would have been, if he had been permitted to see his lawyer, the statement to the mother would never have happened. It's common sense. So given that the statement was introduced and made a feature of the trial, we would respectfully suggest that this case should be remanded for a new trial, and that evidence should be suppressed. And if the state is so adamant that the other evidence was so compelling, they shouldn't be fearful of retrying the case without that evidence. But I think that we all understand that those other witnesses could have been undermined at trial, and that could not happen with the statement to the mother. I'll reserve 5 minutes for rebuttal if there are no other questions.
Very well. Thank you, sir. Ms. Sims?
May it please the court, my name is Lindsay Sims Bonensteel of the Office of the Attorney General, and we represent the appellee in this matter, the state of Florida. To start with appellant's issue 3, the admission at trial of the statements to the mother. And I'm going to make some statements probably for clarity that will also go to the issue 2, the motion for judgment of acquittal. Appellant's partial admission to his mother didn't have the weight at trial that opposing counsel would characterize it in this case. First, this was a partial admission to an accidental shooting, not to the first-degree murder charge. And it did occur in the police station after appellant had given statements to the officers. But this was a purely voluntary statement that he gave to his mother. There was no reasonable expectation of privacy in that law enforcement interview room. The door was open, and in the video, you can hear the ambient noise coming through the door. In fact, if you watch Courts Exhibit 1, which is at about 1520 of the second supplemental record, you'll see a moment after he makes a statement to his mom. Appellant wants to speak with Detective Cruz. He wants to ask a question about how outcomes, essentially. And when he wants to talk to Cruz privately, he closes that door so his mom can't hear. And I think that makes it pretty clear that he was aware that the officers were right there.
Well,
Certainly,
that may go to the question of whether there was an expectation of privacy in that open room, but it doesn't address your colleague's point that those statements would never have been made if counsel had access when he first requested it.
Well, to address that, opposing counsel would have us think that but for the statements that he had made to law enforcement, that never would have occurred, this conversation with his mother. That's not the analysis. And under McAdams, the Florida Supreme Court, under Article 1, Section 9, would have us suppress statements, voluntary statements given to law enforcement. The statement that he made to his mother wasn't a statement to law enforcement. It was a voluntary statement, like a jail call or a visit or statements made in a police car that had no, the conduct of the officers had no effect on this. This is also a case in which our position below and on appeal is that those officers didn't know that the attorney was downstairs. Now there's the rule, it's a bright line rule that they're going to suppress the statements, that what was in the officer's mind doesn't matter. Certainly, they didn't commit any misconduct by bringing the mother there. They didn't do it in order to seek a statement from appellant. They already had the confession, and they also already knew from two other witnesses that would be witnesses at trial, Alex Dunmeyer and Senior Airman Lawrence Owens, that appellant had confessed to them as well. So under McAdams, we wouldn't, or any other case law that we have, we wouldn't extend that prophylactic rule to suppress evidence to a voluntary statement made to mother in the witness room. Now, the trial court did suppress all the statements that appellant made to Detective Cruz and Detective Miller in that interview room. They also went on to suppress what is the real fruit of that interview, evidence that was collected at appellant's home, shoes, and any other evidence. So certainly, appellant was protected at trial by the state not being able to introduce any evidence that was a result of him not being informed that his attorney was present. If there's no questions about issue number 3, briefly on issue number 1, this relates to issue number 3. Because the trial court suppressed all the information that was imparted to Detective Cruz and Detective Miller, this issue of suppression, the other issue of suppression, was whether he had sufficient IQ to knowingly, intelligently, and voluntarily waive Miranda as he did, would be moot. This evidence, whenever it was admitted at trial. Certainly, there was no Daubert objection raised below, and that even considering that, appellant's argument, the fact that he didn't give an IQ test, would go to the weight of the evidence that the doctor gave and not to its admissibility. And certainly the doctor gave evidence that would substantiate trial court finding that he didn't have an IQ of 58. I think it's apparent from the video too that he understands what the officers are asking him. He's very clear. He has a good rapport, and he's well spoken. Certainly not an IQ of 58, as Dr. Garmouche points out. His adaptive behavior doesn't fit that diagnosis. And also, it was nothing that they noticed in school, although they noticed other things. They were federally obligated to track appellant's progress in school, and none of this was noted. As to the motion for judgment of acquittal, the trial court did not err when it sent this case to the jury. There was an abundance of evidence in this case. First, we hear from Jamal Reed, who was eyewitness to the events of the murder. He didn't identify appellant because he didn't see the shooter very much. He was sort of, he answers the door, he goes to speak to the victim who's in another room. He's grabbed from the side, a gun's put to his head. Eventually, when the shooting starts, he gets pushed aside and he's held by somebody who has a taser point. And when the shooting starts, both of those men drop to the floor. After the shooting, the suspect runs away. Ashley Clark, who was also there, she was in the other room the entire time, so she didn't have an opportunity to see appellant or make an ID. But we do have the testimony of Javonte Johnson. Javonte Johnson was the driver, and he sees appellant moments after the shooting come in the car. He's got blood on him. He's got the gun in his hand, and he says, "I shot somebody." The co-defendant, Javonte Johnson, and another man named Rashondo Johnson testifies at trial that they go to his house. He's actually just a guy looking for a ride, but he gives him an accelerant, and they burned some material at his home. Afterward, Javonte Johnson will testify that later that night, he takes appellant to go and, according to what he sees, him get rid of the gun. Now, his testimony could be attacked, could be impeached, or he could have his credibility attacked. And this was explored at the jury trial, that he had received a plea. But what Javonte Johnson says is he would have testified anyway. He would have testified because he didn't want to be a part of this. Corroborating his testimony is the confessions that appellant gives to his two neighbors. And he gives these confessions independently. The two neighbors didn't talk to one another. One is Alex Dunnemeyer, and the other is Senior Airman Owens. Alex Dunnemeyer explains that he knew that appellant was planning a robbery. Appellant had told him. He had seen appellant purchase a gun. He'd seen the appellant with a gun and with a taser. In fact, he asks Dunnemeyer to be the driver, and Dunnemeyer says no. Dunnemeyer sees appellant the evening after the crime. He's distraught. He admits to what had occurred. He admits to being the shooter. In fact, he pulls up on Dunnemeyer's phone the Bay News 9 article about the crime that says that it has the victim's name and the fact that the victim had died. Appellant admits that. He also admits to burning the clothes to Dunnemeyer. Now, these confessions is going to be consistent with what Owens is going to say, but we also have the medical examiner, and the medical examiner and the forensics teams are going to talk about the projectiles that were .380s that were found, bullets recovered from the victim's body, and two projectiles that were recovered from the scene. This was consistent with the firearm that was, and we know what kind of firearm it was because the person who sold him the firearm, Garrett Cooper, testified at the trial about it. Numerous witnesses, including Jamal Reed and Javonte Johnson, looked at the picture of the same type of firearm, because we don't have the firearm at trial, same type of firearm and say, yes, that was just like the firearm that he had. It was notable because it was small and it was palm-sized. Jamal Reed will recognize the sound of a small gun. He'll describe the pop, pop, pop when this victim is murdered. Owens, the senior airman who comes in and testifies last, and in fact, it's Airman Owens who is the centerpiece of the state's case. So he comes in and he affirms everything that Dunnemeyer has said. The appellant told him about the crime, how it occurred, that there was a fight for the gun. And Owens also knew that this was planned. Testifies to the shooting. It all went wrong, he says. In fact, he tells Owens, and it's chilling, that he then took a step back and point blank range fired the remaining 6 shots into the victim's chest. He also confirms with Owens the Bay News 9 article about the victim. And that 6 shots that was fired into the victim's chest is consistent with the medical examiner testimony, some of which included the fact that at least one of the shots, the medical examiner testimony is a little hard to understand because they're doing a lot of positioning, but it's clear on the record in this case that that victim was down on the ground when the shooter was standing over him. So with all this evidence against appellant, certainly it was appropriate for the trial court to deny the motion for judgment of acquittal and send this case to the jury. Returning to issue 3, if we explore the evidence a little bit, certainly this partial admission that he made to mom, which is very brief, even if it was talked about during trial, this was played and presented in evidence in the middle of the trial. And although on rebuttal close, the state makes a little bit of it in terms of kind of a rhetorical device, but certainly the centerpiece of this case is the fact that this appellant made admission to several individuals that's all consistent, and it's consistent with the evidence that was at the location of the shooting and from the medical examiner that this occurs. And in other case law in Florida, I've noted in my brief, where appellant makes admissions, particularly multiple admissions that are consistent with the scene, this is sufficient for the motion of judgment of acquittal. Certainly the admission of the statements to his mother was not error, it was not fundamental error, and it was also harmless error. If it was error, any error was harmless because of the powerful evidence from Javonte Johnson, Alex Dunnemeyer, and Senior Airman Owens. If there are no questions as to any remaining issue, I will rely on the arguments set forth in my brief, and we ask the court to affirm the judgment and sentence in this case.
Thank you, counsel. Mr. Trevena?
Thank you. The analysis is not whether or not there was other supporting evidence to sustain the conviction. The analysis is whether or not the improperly admitted evidence, in this case, the confession to the mother, contributed to the verdict. And as I said initially, I don't see how anyone can argue that that evidence that was made a feature of the state's case did not at least contribute to the verdict in this case. And that's what the case law says. So I think we have successfully established that there was a contribution.
Well, I think another way to look at this would be to say if that admission to the mother was not present, would he have been convicted anyway?
And as I said earlier, I think any competent trial lawyer could have helped undermine some of the other witnesses' testimony. And none of that was direct evidence. It was circumstantial in nature when he's talking about when the state's arguing that, the firearm is consistent with the forensics with regard to the autopsy and such. I think that at trial that evidence could have been challenged and would have been challenged by defense counsel. And then we have to go back again to McAdams and just reading the exact language of the ruling in McAdams. It's a bright line rule, and it says specifically any, that's the key word, any evidence collected between the time McAdams was in custody and when law enforcement informed him of the attorney should have been suppressed as a violation of Florida's due process clause. The court went on to rule that the prophylactic rule also applies to voluntary statements. So in this case, it is very clear that but for allowing that evidence to go before the jury contradicted what would have really happened had Mr. Hunt been permitted to consult with his counsel. There would have been no statements. There would have been nothing to produce to the jury. And as a result, he was convicted, at least in part. It was contributed to the guilty verdict. And I think in this case, it's abundantly clear that that happened. Yes, there may have been other evidence that could have been challenged. And as I said before as well, if that's the case, then let's follow the case law, remand the case back, and let the state try the case without that evidence and see what happens. But I think that the client, Mr. Hunt, deserves that opportunity to be judged on the admissible evidence rather than say, oh, well, it's harmless error. It's not a big deal. It's a huge deal. It was mentioned throughout the entire trial. It was the feature of the case. It was the most damaging evidence. His statement to the mother cannot be undermined, whereas other evidence could have been. So given that was so crucial and certainly contributed to the verdict, I don't see any other option that the court has other than to remand this back and have them try this case without that confession to the mother. That's all I have, if there are no further questions.
Thank you, sir. Thank you both for good argument.
Thank you.
Thank you.